In a significant development with wide-reaching implications, the United States Supreme Court on Friday granted the Trump administration the authority to halt a humanitarian parole program that was initially introduced during the Biden presidency. The program had previously provided temporary legal status to approximately 530,000 immigrants from Cuba, Haiti, Nicaragua, and Venezuela, allowing them to reside and work in the U.S. while fleeing dire conditions in their home countries. This decision marks the second time in just a few weeks that the High Court has supported the administration's efforts to roll back protections for migrants. Earlier this month, the court cleared the path for revoking a separate policy that had enabled thousands of Venezuelans to obtain work permits and remain in the United States on a temporary basis. As is common with emergency rulings, the court's order was unsigned and did not include a written explanation from the majority. However, the two most liberal justices on the bench, Sonia Sotomayor and Ketanji Brown Jackson, voiced strong opposition in a sharply worded dissent. Their opinion criticized the majority for failing to account for the serious harm that could come to individuals facing imminent deportation. Justice Jackson argued that the majority had misapplied the legal standards used to determine whether an injunction should remain in place, while the lower courts continue to consider the broader legal issues. She emphasized that hundreds of thousands of lives would be disrupted and livelihoods jeopardized as a result of a hasty policy reversal. The court has effectively decided that it is more equitable to favor the government's interests, even if that means tearing apart the lives of over 500,000 people before their legal rights have been fully evaluated, Justice Jackson wrote. This approach fails to recognize the severe humanitarian consequences of such a decision. While the ruling is not a final resolution, and the underlying legal challenges will continue in lower courts, the immediate effect is that the federal government can now move forward more quickly with deportation proceedings. Many of those affected have been living and working in the United States legally under parole program, which is now abruptly being curtailed. The outcome is expected to significantly increase the number of migrants eligible for removal, even though many of them would resist returning to the dangerous or unstable conditions from which they originally fled. The case underscores the increasingly high stakes surrounding the use of the Supreme Court's emergency docket to make impactful immigration decisions without full briefings or oral arguments. Humanitarian parole, a policy tool embedded in U.S. immigration law since the 1950s, gives presidential administrations the discretion to allow certain migrants to enter the country on a temporary basis for urgent reasons. The policy has historically been used during international crises, such as when the Eisenhower administration permitted the entry of thousands of Hungarian refugees escaping Soviet repression. Although parole recipients are granted the ability to live and work legally in the U.S., the status is temporary and does not lead to permanent residency unless they qualify under other immigration provisions. The Trump administration's decision to terminate this program reflects a broader shift toward more restrictive immigration measures and a rollback of temporary protections granted by previous administrations. As the legal battles continue, the fate of hundreds of thousands of migrants remains uncertain, caught between shifting political agendas and the slow-moving wheels of the judicial process. The Biden administration, in an effort to manage migration flows more humanely and efficiently, launched a policy in 2023 allowing certain individuals from Cuba, Haiti, Nicaragua, and Venezuela to apply for temporary entry into the United States under strict conditions. Under the program, migrants would gain legal entry if they pass background checks, secured a U.S.-based sponsor, and agreed to undergo a formal screening process rather than entering the country unlawfully. However, this initiative faced swift opposition from former President Donald Trump. On his first day back in office, Trump signed an executive order directing the immediate suspension of the parole program, signaling a dramatic policy reversal aimed at reestablishing stricter immigration controls. While it is widely acknowledged that the Secretary of Homeland Security, currently Kristi Noem, possesses broad statutory authority to grant or rescind parole under federal law, the legal conflict centers on whether that authority can be exercised in sweeping fashion or must be applied on a case-by-case basis. The Biden administration has claimed it did evaluate individual applications before granting parole, but critics argue that revoking the status en masse is not consistent with the intent of the law. In a filing to the Supreme Court, the Trump administration emphasized the magnitude of its action, describing the termination of the parole program as one of the most significant immigration policy decisions it had undertaken. It argued that lower court decisions temporarily halting the termination had disrupted essential strategies aimed at discouraging unauthorized border crossings. The administration contended that these judicial interventions were undermining executive authority and rolling back immigration policies that played a central role in the recent national election. Legal challenges soon followed. A group of migrants who had been admitted under the parole policy filed suit, prompting U.S. District Judge Indira Talwani to issue a temporary injunction against the administration's attempt to dismantle the program entirely. Judge Talwani clarified that while the administration could choose to end parole on a case-by-case basis, it was not permitted to invalidate the status of all participants simultaneously without individualized assessments. Appointed to the federal bench in 2013, Talwani was nominated by former President Barack Obama. The legal pushback continued in the appellate courts. On May 5th, the First Circuit Court of Appeals in Boston refused to stay Judge Talwani's order, effectively allowing the lower court's block to remain in place. The three-judge panel, comprised of 2 Biden appointees and 1 from the Obama administration, voiced doubts about whether the Department of Homeland Security had the legal authority to terminate the program across the board. This parole case is just one of several emergency appeals related to immigration that have landed before the Supreme Court since Trump returned to office. Among them is a controversial proposal to end birthright citizenship, which was argued before the High Court on May 15th. These cases collectively underscore the high-stakes battles over presidential power, immigration enforcement, and the judiciary's role in safeguarding constitutional protections. The Supreme Court has also addressed a number of other immigration-related matters in recent months. In one instance, it ordered federal authorities to help facilitate the return of a Salvadoran national who had been mistakenly deported earlier in the year. Additionally, the court has repeatedly intervened to block the administration from invoking an obscure 18th century wartime statute to justify the rapid expulsion of Venezuelan migrants located in northern Texas. These ongoing disputes reflect the growing tension between executive branch ambitions and judicial oversight when it comes to immigration reform. As legal proceedings move forward, the fate of hundreds of thousands of vulnerable individuals continues to hang in the balance, caught in a legal and political tug-of-war that shows no signs of easing soon.